Good morning. If everyone has been able to connect successfully, is the session on evidence and arbitration, the second program in our arbitration track this morning. Welcome, everyone. I want to introduce myself. I'm Larry Saylor. I'm a senior principal at Miller Canfield. I've practiced commercial litigation for many years and now spending a lot of time on arbitration, mediation, and case evaluation. I want to introduce the other members of our panel. Jan Holdinsky is a regional vice president for AAA based in Novi. Betty Widgeon is a former chief judge of the 14A District Court in Ann Arbor, now a mediator, arbitrator, and fact finder. And then we have Marty Wiseman, who's having some technical issues, but hopefully he'll join us momentarily. He's a commercial litigator and an experienced arbitrator and mediator. Principal at Wiseman, Young, and Rubenap in Bingham Farms. What we're going to cover today dovetails nicely, I think, with the program that you may have just seen on protecting the award. One of the few grounds in the statutes and court rules, both in the Michigan statutes and in the Federal Arbitration Act, for vacating an arbitration award is where the arbitrator has refused to consider or hear relevant evidence. And welcome, Marty. Glad you were able to join us.
Yeah.
So that sets up a potential conflict or at least tension with the many rules that allow arbitrators to restrict the amount of evidence either available to the parties or admissible in the proceeding. The AAA rules provide that conformity to legal rules of evidence shall not be necessary. On the other hand, the arbitrator can determine the admissibility, relevance, and materiality of the evidence offered and can exclude evidence deemed by the arbitrator to be cumulative or irrelevant. Arbitrators can grant dispositive motions, which of course can limit the amount of evidence available or admissible at the hearing. Arbitrators can, and in fact should, limit the amount of discovery the parties can conduct in arbitration. And that, of course, can impact the party's ability to discover evidence and therefore offer the evidence in the proceeding. And arbitrators can even impose sanctions, including adverse inferences and exclusion of evidence in appropriate cases. All of that may limit the amount of evidence that the parties offer or that the arbitrator is willing to receive and consider. And the goal of arbitration is to be both fair and efficient. So how have arbitrators and the courts balanced these potentially conflicting statutes, rules, and goals? We're going to hear from an experienced and distinguished panel on how they've confronted and handled those types of issues. First off, we'll hear from Betty Widgeon. Betty, have you had occasion in your practice to consider pre-hearing motions or other matters in advance of the hearing that might restrict the availability of evidence, like motions that eliminate dispositive motions or motions involving discovery issues?
Well, Larry, I'm going to start by just basically saying that discovery in general is much more limited in labor arbitration than in employment arbitration. And that includes the tool of dispositive motions. Now, most of my practice, probably about 85% of it, is in labor arbitration, but I do some employment and some commercial and consumer also. But let me just talk about the differences, some major differences, and I'll swing back around to that question. A little background about some of the differences would include this. One of our colleagues, Lee Hornberger, describes it this way. Labor arbitration and employment arbitration are distant cousins, and that's because they serve different purposes. In employment arbitration, the parties look to statutory law and to case law as a judge would. Employment arbitration is a substitute then for court litigation. It's conducted under individual employment contracts, handbooks, and policies. And employment arbitration uses motion practice extensively, and that does include the dispositive motions you were talking about. As for any relationship between the parties, this also is a difference. It's usually a one and done situation as far as the advocates, as far as the parties are concerned. Employment arbitrators are required to make, and I'm sure Jan will speak about this too, extensive disclosures concerning current and past dealings with parties and attorneys or advocates in the cases. This makes sense because employment arbitrators may still be practicing employment law and representing clients. So here's a contrast. Labor arbitration is not a substitute for court litigation. Rather, it's a substitute for industrial strife and strikes that we're avoiding. It comes about as a result of collective bargaining between the parties. In labor arbitration, there's a balance of power between the union and the employer. The grievance belongs to the union. The two parties are the employer and the union, not the employer versus John Smith or Samantha Johnson. And that collective bargaining agreement, referred to as the CBA, sets an elaborate, it sets forth elaborate pre-arbitration steps that bind the parties. Another difference is that with labor arbitration, both sides are repeat players. It's not a one and done. There's generally an ongoing relationship. Counsel may have a dozen or more cases together in any given year, and they may resolve even 3 times as many or more. The parties agree to language that provides that all grievances may eventually be submitted to labor arbitration. And that is all of them that aren't resolved in the defined steps below. That's a pretty important clause because it's not just those that a court might deem to be meritorious. As some have noted, even frivolous grievances may have a therapeutic value with, and those who aren't a part of this plant environment may be unaware of this. Just going to mention a third difference, and that is that labor arbitrators they may not represent management or unions, and therefore there's not generally a requirement for them to make extensive disclosures of relationships to the parties. Labor arbitrators may arbitrate for the same parties on a regular basis, and sometimes it may even be on a monthly basis or more. So getting back to your question, Larry, on dispositive motions and other discovery tools, they are much more limited in labor arbitration because the CBA itself sets forth discovery before the appeal that the union makes to arbitration. The parties generally build into the grievance procedure rules that affirmative defenses must be brought up early on, or the parties are stopped from asserting them later. And parties will be very familiar with those rules. So the arbitrators must be familiar with them in order to rule on substantive and procedural arbitrability issues that might arise during the hearing. By the way, those arbitrability issues will serve somewhat the same as those motions for excluding evidence, but it's based on what has already been set forth in the CBA. Discovery after the appeal to arbitration is usually limited, and that's limited to perhaps subpoenas for witnesses, in some cases for the production of a few documents, and even in fewer cases for a deposition of a witness who can't appear. So the standard for permitting discovery after the appeal to arbitration would be this: as an arbitrator determines it is appropriate.
Okay, well, hopefully it'll work on the
under
next
the
one then.
circumstances.
Must have, I think it all started with me clicking on Jennifer's.
Mary Ann, you're not muted.
Oh, I'm sorry.
All right, so that's basically what I wanted to say, Larry, about why it is that discovery is quite limited in labor arbitration, which is what I do most of, more prevalent in employment arbitration.
Eddie, thank you. Same question to Marty. What share your experiences with matters, either motions pre-hearing that might impact or limit the amount of evidence the parties can offer?
Well, in civil commercial arbitrations is very different than what Betty was talking about, because most of the advocates are coming from a general court proceeding into arbitrations, or their mindset is such, and they carry that over thinking that an arbitration is going to be the same as a court proceeding, but it's not. And dealing with the counsel in the pre-hearing area, and before I issue my pre-hearing order, I go over the approach that I use, particularly with regard to dispositive motions, motions in limine, whether or not experts are involved, and therefore we would need a Dauber hearing. Those are the kinds of things that I discuss at the pre-hearing. And I advise them that with dispositive motions in a commercial setting, in general, arbitrators, and particularly myself, let them know that they are very hard to be successful. In general, they are not. And I tell the counsel and the advocates, don't bring these kinds of motions unless there are no factual bases for any of them. If they are purely a legal issue, those are the kinds of dispositive motions that I would be inclined to hear. Statute of frauds, statute of limitations. The other thing that I do to try to manage pre-hearing motions is to require, before filing a motion, one, they have to certify that they have had a good faith discussion with opposing counsel and that there has been no agreement reached between them. Secondly, I require a short letter of not more than 3 pages, double spaced, without exhibits, stating why the motion has merit, why it is likely to be granted, and why is it likely to produce a savings in time and costs. And then I give opposing side a similar opportunity to respond to that letter, 3 pages, double spaced, without exhibits. And then I take a look at those two and decide whether or not I will even allow the motion to proceed. If I do allow it to proceed, I then set a briefing schedule and perhaps a time for argument. But in general, at that point, I can cut off it at the pass and not proceed. Similarly, in commercial matters, you have a lot of expert testimony, and occasionally you come to pass to have an argument on whether or not an expert is permissible or not permissible, helpful or not helpful. In general, again, I require the same process as I do with dispositive motions, and I advise them, in light of the fact that we want to be inclusive and make sure all parties have the opportunity to present the evidence they want and thereby attempt to bulletproof our decision. I say that you got a pretty high road to go in order to try to stop an expert from testifying. I mean, that's generally what I do in advance with the pre-hearing motions. I don't treat discovery motions the same way. I do require certification before any discovery motion is brought that they have met and conferred and could not reach an agreement. And then generally I just require it on paper, and then I would issue my opinion accordingly. I have found that that is particularly effective also with motions in limine. Again, going back to the bias, that one of the grounds for vacator is not hearing all of the evidence. So you got to be very careful, and I advise them I'm going to be very cautious in granting any motion in limine, and that as an experienced arbitrator, I really know how much weight I should be putting on what, and I will try to do so. And I let them know that in advance, so at least they know what they're getting into. And that's generally the approach that I have with the pre-hearing motions, particularly on the dispositive side.
Yeah, those are
Larry,
all-
can I make a comment on that?
Sure, please.
Excuse me. So as Betty described and as Marty described, labor and employment are on two very different tracks. In labor, rarely does an arbitrator get involved with any kind of discovery issue. And it's probably even more rare that a motion is even submitted. It is kind of amusing that the only thing an arbitrator has in advance of the hearing is probably the demand request that has been submitted by the union. Labor doesn't even have pre-hearing calls, preliminary hearings, or anything like that where it's even discussed. On the employment side, AAA did change their rules over the years where, and as Marty described, motions is not an automatic anymore. It is with permission of the arbitrator. In the past, motions came in our door left and right from the parties. It could be a motion to postpone. It could be a motion to produce discovery. It could be a motion on whatever it might be. And as Marty made reference, you know, if an arbitrator is satisfied that that motion is going to narrow the issues or maybe even resolve the issues, then they may decide to entertain that motion, but it's no longer a given. And I just wanted to put emphasis on that.
And I'll just offer that, and there was a time when I went through AAA training for new arbitrators that dispositive motions were extraordinarily rare and were really discouraged. And that's not quite any longer the case. And I've actually found dispositive motions in some fairly complex commercial matters to be helpful in narrowing down the issues, especially things like issue preclusion, the statute of limitations, as Marty indicated, and the like, and perhaps contractual interpretation if you have a clear contract and there's not substantial evidence that's being offered to try to somehow introduce an ambiguity. And those motions can lead, decisions on those motions can also lead to settlement and help the parties to resolve their issues, although maybe reduce the amount of work that the arbitrator gets to do. In the case, Marty, did you have a?
Yeah, I wanted to comment on that. That's true, but there's the caveat to it is, again, the bias is to allow the parties to be able to present their evidence. And if you cut off rights to present certain evidence, that may lead to a claim, at least, that you impaired their ability to present their case and therefore a ground for vacator. So what I generally do is, if there is a motion that allows you to shorten or make the hearing more efficient, that is legally based as opposed to factually based, then that is the kind that you should be really considering whether or not to allow and whether or not to grant. But if there are factual issues that undermine that legal issue, then you have to be very cautious, because that's where you can run into vacator type trouble.
Right, very, very true.
And Larry, I'll add one more comment too. I'm thinking about with employment arbitration, those decisions about motions, what they will be, what the limits will be, those are set forth in the pre-hearing order. So as an employment arbitrator, I already have that information after the case management conference. So I know where we're going with that, and the timeline is already set. With labor arbitration, as Jan said, we don't get a lot. Sometimes we don't even get that grievance that's laid out, Jan. Sometimes we only get whether or not it's a contract interpretation matter or whether it has to do with some kind of discipline. And I set forth before that there are a lot of steps that parties put into their pre-arbitration procedure that takes care of this, but every now and then you'll find that a party doesn't cooperate, and you will have them coming. I had that recently, coming to the arbitrator and saying, look, we need this information to really put our case on. We know it was a subcontracting issue. We know that some things have happened, but the other side hasn't really been complying like they were supposed to in the steps below. So in that case, and that's rare, the arbitrator will get in and will help that process along, make some decisions.
And I think that it's worth saying that if, whether you grant or deny a pre-hearing motion that might impact the availability or admission of evidence, you should have a good sound reason for what you've done and one that you think will hold up if the award is ultimately challenged. And my personal bias is that that should be done in a reasoned award, although the rules certainly don't require reasoned awards. So if you're going to do it in a kind of a summary type award, you better at least have a very good reason that you think is going to hold up if there's a challenge to the award. So this is probably a good time then to segue to the next part of our program, which is how do you handle evidentiary objections that come up during the hearing after you've gotten past all the pre-hearing motion practice. Jan, do you want to lead us off on that one?
Sure. So let me begin by saying that there is a provision in our key arbitration rules, commercial construction and employment, and my comments are, you know, based on all sets of rules, and they're all very, very similar. Larry already kind of gave an overview of the evidence section, and that the parties, you know, are capable and are able to offer the evidence that's relevant and material to the dispute, and that the arbitrator is going to determine the admissibility and the relevance and the materiality of all the evidence. The arbitrator also has the authority to issue subpoenas. There's also a section in our rules, all sets of rules, on the conduct of proceeding, and it's pretty straightforward in all sets of rules. So the question is, you know, regarding the evidence, what gives the arbitrator that authority on evidence, and you know, and how the arbitrator decides, you know, how he decides on those evidentiary issues. So as mentioned, you know, the arbitrator's authority actually primarily comes from the set of rules, because there's information that provides the parties and the arbitrator what the guidelines are for evidence. But it also can come from the contract. It also can come from a stipulation of the parties, you know, if they want to give that arbitrator the authority to rule on certain things. Not too often do you see that, but primarily on the employment side, where during that preliminary conference call, the parties might, you know, speak about evidence and what authority are they going to give the arbitrator and things like that. And maybe Marty can, you know, expand on that a little bit when he, you know, comments on that. But there are some best practices and there are some guidelines, you know, that are given to an arbitrator. First of all, an arbitrator has the broad discretion in determining what weight that arbitrator is going to give that evidence. And we're going to talk a little bit more about the weight and how that comes into play, whether it's labor or whether it's employment. I will also say that most arbitrators generally accept the evidence and that the arbitrator will give it the weight that he or she deems appropriate or necessary. This is done to safeguard the final award and to prevent a party to go into court to try to attack that award. Obviously, an arbitrator's objective is to protect their award. And they don't want to give the parties any reason to try to attack that award because they failed to allow certain evidence to come into the process. So some of the guidelines on deciding admissibility that an arbitrator looks at: relevancy and materiality, objections to the evidence that was provided by the other party, the credibility of the person offering the evidence, the circumstances from which the evidence arose, and then any other evidence or testimony that supports or discredits that evidence. So that's kind of like an overview of the evidentiary objections that might come into play.
Marty, your thoughts?
Yeah, I mean, that's a very important thing, and there are ways to minimize the stress on the arbitrator that I utilize. For example, as part of the pre-hearing order, I require that 1 week in advance of the hearing that the parties prepare a joint, consolidated, and comprehensive set of exhibits. And all of those exhibits are deemed to be admitted into evidence without having to do anything further, so that they can just refer to them during the course of the hearing. And then I require that if there are any contested exhibits, that they be submitted in a separate, whether it's a book or however they do it, with an indication as to the nature of the objection. So I will have that material in advance to make a determination whether or not a particular exhibit is objectionable. So you already have a feel for what the evidence is going to be that's presented. Additionally, I always require pre-hearing briefs that identify the legal issues and a summation of the general approach each one is going to be using. So you take those all together, and so you now have a mindset in a commercial setting of what the bake of the evidence is. I also tell them, though, in the pre-hearing conference, that I don't want to hear objections as to the form of question. I mean, that's the typical one. Oh, you're leading the witness and whatever. I tell them, just a waste of time. I prefer to hear it out of the mouth of the witness. But if you're going to lead, it's not going to have as much impact on me as if the witness stated it, but don't bother objecting. And hearsay is another one, evidentiary one, where we get into a lot of arguments. And I generally tell them exactly what a lot of trial judges have said in bench trials. I'll let it in for whatever it's worth. And I tell them the same thing with hearsay objections. Unless it's really going crazy, don't make any hearsay objections. I will give it whatever weight I deem appropriate. And I will tell you, I've been a trial lawyer for many, many years. I know what I'm hearing. I know that generally hearsay is not particularly given a lot of credence, but it's a waste of time to go through that. And I let them know that. But on the other hand, if you have something that deals with the privilege, whether it's the attorney-client privilege or work product privilege, some kind of privilege issue, those are the types of objections that they should make and continue to make, and then we will deal with them as the hearing goes on. And again, I also, like Jan indicated, that one of the arbitrator's primary objective is to protect the award. And so again, you tell the advocates this in advance so they know where you're coming from. I'm doing this because I want to protect the award, and I'm actually protecting you and you, referring to each of the advocates, so that if you come out ahead in this case, your decision is protected. So, that's how I kind of approach it on these civil matters.
All right, we'll turn to Betty in a moment, but Marty, let me flip one around on you. The AAA rules at least make it clear that arbitrators are not necessarily required to follow the strict rules of evidence as would be applied in a court. But could an arbitrator do that? Could an arbitrator say we are going to apply strict evidentiary rules in this proceeding, so don't offer anything that you wouldn't in court?
Well, I think that, under the Uniform Act that we have, the arbitrator has the entire authority to set the process and how the process will play out. So the answer to that question is yes, although I've not seen any arbitrator do that. I believe that they could under the Uniform Act, and I think under the AAA rules they could do it as well. I think that a lot of also in the commercial setting, I see a lot of, by and large, the type of cases that I'm selected as an arbitrator in, fairly experienced arbitrators, rather advocates. And the more experienced the advocate is, the more they understand what I was saying and how I proceed and manage an arbitration hearing. The problem comes in when you have novices as the advocates, and you have to pay them and kind of spoon feed that a little bit more. And you have to be able to let them understand and make them understand that an arbitration proceeding is not a court proceeding, and it has a lot looser rules that allows for the presentation of cases, and let them understand that. And that's the approach that you've got to use.
I do think the looser rules can lead to sort of some abuse by especially inexperienced advocates and unhappy litigants, because you have an issue with cumulative evidence, argumentative evidence, things that really are not moving the ball and can really drag out the hearing. So that's where the arbitrator needs to really think on their feet and try to control the proceeding and keep it moving.
Another issue that comes up too with evidence, I had a very hotly contested employment case, very large numbers, and a very salacious amount of evidence was involved in that case, a lot of stuff. And there were motions dealing with confidentiality and for separating certain evidence from the official record because they didn't want it out in the public. Those are another kind of motion that sometimes you may have to deal with in a very difficult, large case. And you've got to weigh all of the reasons, plus and minuses, and the competence of counsel when you're making those decisions.
Betty, what's been your experience in the employment litigation context with evidentiary issues that come up during the hearing? Oh, you're muted.
Thank you. I was coughing there for a bit. I'm going to speak mainly, Larry, about in the labor arbitration context, but I will mention employment a little bit also. What I will say is that, and I had a few things written down, and I thought of a couple of other things as Jan and Marty were speaking, so I'm going to try and add those in too. But while the rules of evidence are relaxed, arbitrators in either employment or in labor arbitration, they differ widely in how they actually apply those rules. An arbitrator can apply a more or less loose application, and possibly you might do this if you're trying to aid the advocates. One of the things I find in a lot of labor arbitration cases, there are attorneys, but there are also advocates who are not attorneys. And I do say to them and let them know that we're not all attorneys, but even if we are, we're not in a courtroom. And folks are used to giving information in the same way that they got it. So that's what they'll be planning to do in the hearing room. Usually they got this by either seeing or observing something firsthand or hearing about what happened maybe immediately thereafter. I also explained that there are no jurors here that we might be concerned about. And some of the rules of evidence do have that concern about how will the jury really take this information if they get a lot of hearsay in, if they get information that's not relevant, will they be able to separate this? So arbitrators consider ourselves more or perhaps exactly in the role of that judge who is the with a bench trial, not with a jury trial. And we believe that we can make that separation. So that's one of the reasons that we also believe that we can apply the rules of evidence more in a more relaxed state. The other thing that I say, now this is one thing that happens. Even though traditionally we did not have case management meetings in labor arbitration, since the pandemic, several arbitrators have been having that because they had to do the hearings by Zoom or by some other virtual format. And they wanted to check in with the parties to make sure that there weren't any technical glitches that we hadn't really considered. But also it has given an opportunity to get a little bit more information about the case. But I use it to give the parties more information about me and what to expect from me as the arbitrator before they actually get into the hearing. So I'll actually talk about some of the things which, if I don't have a pre-hearing conference discussion, I'll talk about it right before the hearing starts. But I'll let them know how I run the hearing with respect to the rules of evidence in particular. So I do go over some of the things that we've already said. I say that I, as the arbitrator, I'm looking for what will assist me in pulling everything together. I'm looking for reliable evidence. And a lot of times, if it's hearsay within hearsay, we feel that that's not very reliable, but I'm listening to what else is happening in the case. The expectation, I think the biggest expectation of the parties, and this is in labor and in employment arbitration, is that they will be able to present their case. They're looking for that day in court, day in the arbitration room, where they are being heard by the person who has the authority and who will be making the decision. And that's what, of course, lends itself to our concern for procedural fairness and procedural justice. So that is what I would have to say. As far as these leading questions, I also want to hear it from the witness and not from the advocate or the attorney, but I'm not going to step in there and object and tell them what to do. They're going to run the case the way they want to run it. If there's an objection, and I will tell them this, I tell them this in the beginning, just with the advocates or with the attorneys and myself, I'll say, even though the rules of evidence are rather loosely applied, if you have an objection that you really feel like you need to make that objection, and I'm going to handle it as soon as possible, as quickly as possible. I'm going to hear what the other side's response is, and we're going to move quickly through this, but I'm not going to stop you from objecting. If it gets to be too much, we might have a conference in the hallway, but that's usually the way I run it.
There were three other little objections that kind of haven't been mentioned, and I think something that Betty said triggered it, particularly in commercial, and that is objections as to relevance, cumulative, or foundational issues. With regard to the foundational ones, because of how I handled exhibit books and objection to exhibits, I mean, a lot of the foundation issues go away. And I also did say that for the purposes of providing foundation for business records, which is usually something that happens in commercial arbitrations, an affidavit from the keeper of the records will be sufficient, and they won't have to bring in a witness to testify that these records were kept in the ordinary course, et cetera, et cetera. So I try to head off some of the foundation kinds of objections. And with regard to relevance, I treat that the same way that I treat hearsay objections, to say that, look, if it's so far afield, I'm not going to give it any weight. But let's just go and keep this thing flowing. And as far as cumulative information, in the pre-hearing conference, I say you don't have to prove absolutely what you have already proven positively. And so I said, just keep that cumulative evidence down. So those are I wanted to mention those three objections and how they arise in the commercial setting.
Thank you, Marty.
Yeah, go ahead.
I was just going to say, if there are questions, please post them in chat, since we're in a webinar format, and we'll be happy to deal with those either as they come up or at the end of the program. The one other issue that we wanted to cover in our in the program is the possibility of addressing some of these issues by using narrative witness statements. Those are permissible now under the AAA rules and have been used for many years in Public Service Commission and international arbitration. So Marty, can you lead us off on that?
Yeah, it's an interesting phenomenon that actually I was introduced to it by Jerry Rock, a well-experienced arbitrator and mediator, and I sort of was doing something like that with expert witnesses in commercial cases. I was telling everyone that, and part of my pre-hearing order is that the written report of an expert will be deemed their direct testimony. And the only issue would be that they have to present that expert witness at the time of the hearing for cross-examination by the opposing side. And then I would give a liberal rebuttal back to the offering person. And I have found that that really worked very well. Using narrative witness statements is the next step forward, and it is a very, very interesting approach that I have attempted in at least 3 or 4 cases now. And what that is, it's a method for presenting direct testimony of fact by a fact witness under the control of that particular advocate, and that the witness's entire testimony is set forth in a question and answer format, signed under oath and entered in the record, as long as that witness then would be presented for cross-examination at the hearing. It's a little bit different than an affidavit because it's a question and answer format, but it provides, and if it's done properly and it's done early in the process, opposing counsel then will have the testimony and will be able to effectively prepare their cross-examination. You cut down the time significantly where there's a regurgitation by the plaintiff of the required facts in order to make a prima facie case. So there are benefits to the arbitrator by making the process more efficient and less costly without sacrificing the interest of justice. It also provides the arbitrator in advance with a way of avoiding the issues of hearsay, cumulative relevance, foundation, all of the other issues that may occur during a live hearing. And there are no surprises in this format. And certainly the arbitrator then will have a better understanding going into the hearings as to what the case is all about. Claimants, on the other side, if this is the claimant perspective, it's like a final work product, and counsel can be confident that the material elements of the case can be presented accurately and completely, and not having all of the issues of evidentiary objections. And normal cross-examination would follow. And in general, I have these witness statements exchanged early, several weeks before the date of the trial, so that it is a very interesting method of trying to narrow down the procedures. From the respondent perspectives, since they're getting the witness statements that are exchanged in advance, they have the ability to make an effective cross-examination, and is better to prepared to present impeachment or rebuttal. So, I mean, it's a win-win for everybody if it's used properly. And then what I have done in the 3 or 4 cases that I've tried this now, in the early pre-hearing conference, discuss whether or not this approach will be used. And if it is used, we prepare together with counsel a protocol and how the witness statements will be done, and et cetera. Maybe they don't want to have a question and answer format. Maybe they just want it like an affidavit format, and that affidavit would be provided as the direct exam, and they would have rebuttal after the cross-exam. Those kinds of things get worked out during the pre-hearing conference. And so the protocol itself that you establish, yeah, there might be some base points, but it's very flexible. And certainly if council had used them before, it makes it easy. But if it's a new fangled idea, which, I tiptoed through it the first couple of times, not knowing what would happen. And then I asked the parties at the conclusion whether or not they found it good, bad, or indifferent. And all of them felt that it was extremely helpful, both on both sides. And they both thought that it made it a quicker, shorter, and less costly process. So it's worth a shot. And that's another way of avoiding evidentiary issues, because once you have that agreement and once you have this narrative witness statement, it is what it is. I mean, it's pretty hard for them at that point to complain that it was hearsay or cumulative or not relevant, etc.
Yeah, I personally have not tried it in arbitration, although I have experience in the Public Service Commission with the procedure and liked it a lot. You have the smoothest direct examination you will ever have using the narrative witness statement. So I'll look for opportunities to use that in arbitration. Betty, have you had opportunity to try the narrative witness statement?
I have not, and we probably definitely would not be using it in labor arbitration, because the whole premise is that you're going to be able to get in there and tell your story, and it might not be straightforward. It might be a little bit messy, but you're going to get that out. The thing that I said earlier about sometimes claims that might seem to be a little frivolous, there's still a therapeutic reason for having those, because we're talking about parties who are going to be working together for years. And so that is something that I don't think those narrative witness statements would be as satisfying, but I have not had that experience. I think there's one question maybe in the chat.
There are a couple of questions. And I'll just mention that I think that narrative witness statement would be a good approach for expert testimony in particular, because it's sort of redundant to have both an expert report, if you have an expert report, and direct examination of the expert. Ed Pappas has asked, what do you do with an objection to evidence that was requested in discovery but wasn't produced?
Well, what I would do, a lot depends upon whether or not there was any request or to enforce a production request prior to that. But I think that if it was just a new piece of evidence, the main thing that I would do is indicate that I'm going to admit it, but I will give the other side an opportunity, a delay, or some time to figure out what they need to do to deal with that particular evidence. If they had requested it, and if there was a motion to compel or a request to compel or a problem and it still wasn't produced, then I may have a more difficult time with it, and it's possible to leave it out.
And one other question from Sheldon Larkey, who asks, have you seen a narrative witness statement done through a court reporter?
No, to me, that's just a de bene esse deposition. Is maybe that would be the equivalent of it through a court reporter, but I've never seen that. If the parties would have agreed to that when we discussed the protocol, then I would allow it, but I haven't seen it.
All right, I think we're right at the end of our time period. I invite all to take a look at the materials. I've cited some cases. We have some outlines of materials, and of course, more complete bios of the panel. So thank you all for attending the conference and in our session.
Thank you.
Thanks, everybody.
Thank you.
Thanks, guys.